Matter of the protest filed by El Sol Contracting and Construction Corporation. May we please have appearances of counsel?
Morning, Thomas Abate, Dakota Fitzpatrick, Cole, and Goodwin on behalf of the New Jersey Turnpike Authority.
Good morning, Michael McKenna, Timothy Ryan, Cohen Seglius, and we are here on behalf of El Sol.
Good morning, counsel, and welcome. Mr. Abate, please.
If I may I have 5 minutes for rebuttal?
I'll have you back for rebuttal, perhaps for a little less. Go ahead.
Sure. Thank you. May it please the court, on behalf of the appellant, the New Jersey Turnpike Authority, let me start by saying that in the modern era of this court's precedence in the arena of public procurement, it has long been held that the predominant interests of fairness, transparency, and the avoidance of misconduct in the bidding process requires adherence to certain procedural formalities. Nowhere is that more true than in the realm of bid security. Time and again, this court's precedents for decades have emphasized that irregularities with respect to bid securities measured as the time of bid submission require bid rejection. This overarching principle of ensuring procedural regularity and maintaining public confidence and fairness in the bidding process has predominated in this court's decisional law over the immediate desire to obtain the lowest price in any given case. Indeed, in this court's decision in 1957 in Township of Hillside versus Sternin, it was held, quote, "In this field, it is better to leave the door tightly closed than to permit it to be ajar, thus necessitating forevermore speculation as to whether or not it was purposely left that way," end of quote. Following that line of reasoning, some decades later in 1994, in Meadowbrook Carding versus Borough of Island Heights, this court followed that principle and held that waiving irregularities in the bid security may, quote, "occasionally may result in additional cost to the public, but we have no doubt that the overriding interest in ensuring the integrity of the bidding process is more important than the isolated savings at stake." And it is in that decision, as this court is no doubt aware, that it was held that a failure to timely submit a consent of surety, the very bid security instrument at issue in this case, measured of the time of bid submission, is a cause for rejection, a mandatory cause for rejection. The Turnpike Authority and other contracting agencies throughout this state have relied upon these precedents and their progeny for decades, and have taken at face value that irregularities occurring at the time of bid submission are automatic causes of rejection. And sometimes, as the Sternin court noted, this may occasionally result in higher price, but this court long ago settled the law in this field and said that ensuring a level playing field, fairness, transparency, and openness, and avoiding any suggestion of improvidence or irregularity is more important than letting the occasional error slip by.
Is it true that the Turnpike, Authority has accepted consent of surety, power of attorney forms with the same defect that is the subject of this case on a number of prior occasions?
Yes, that's correct. On 13 occasions, the Turnpike Authority accepted the very same consent of surety and power of attorney form.
And is it the Turnpike's authority that Turnpike Authority's position that it made mistakes when it accepted the same form on those 13 prior occasions?
Yes, that's right. Look, it's not the best set of facts, and it's not the best circumstance for the Turnpike Authority that those forms were allowed, those powers of attorney were accepted. Our staff acted in good faith. There were some adjustments to the bid process where it was missed. It was frankly missed, I think.
Looking at the 2016 specifications for the bid that was in effect at the time the bids were solicited for the deck rehabilitation project, where in the specs would a bidder be on notice that a POA was needed to accompany the consent of surety?
Okay, certainly. That's section 102.08 plus the consent to surety form itself, 102.08 is at A1 of the record, and the consent to surety form is A4. Before I answer that, just let me say, there was staff at the Turnpike Authority acted in good faith. We changed our bid process. The defect was noted. At the time we noted it, we had an obligation to act under the law, but Meadowbrook says we have to reject this. It's unfortunate. It's unfortunate for El Sol. It's unfortunate for us that it was missed previously. But once we noticed it, and it came to the attention of the law department, there became an obligation to act.
So counsel, following up on the
I will
justice's
answer-
question,
yes.
there are 3 sentences in 102.08. Point us to the specific language that you're relying upon that says things were not done right here. They were required and they were not done properly.
Right. So just going through it, 102.08, the first sentence is really of no consequence. It establishes that the proposal bond shall be accompanied by a power of attorney and a consent to surety in a form acceptable to the authority, which shall be executed by the surety company. I don't think that the respondent disputes the notion that under that sentence, the consent to surety had to be in a form acceptable to the authority and it had to be executed by the surety company. The second sentence.
Before we leave that, can I ask you if would a bidder be reasonable in concluding based upon 13 prior instances in which the New Jersey Turnpike Authority had accepted a form similar, almost identical to the form that we're dealing with here, that was a form acceptable to the Turnpike Authority? See what I'm saying? It's a form acceptable. If you're relying to any degree on that, they had on 13 prior occasions found that form apparently acceptable. And you're saying, I understand you're conceding that your client made an error in doing that, but that's a pretty long record of it.
Well, I understand your point, Justice Patterson, that maybe they thought it was reasonable, but this court hasn't previously stated that a bidder's subjective belief is a relevant factor to determine with respect to the sufficiency of bid security. And once we identified the error, we couldn't waive it again because then we would affirmatively be engaging in favoritism, and this court's precedents divested us of that discretion in our view.
So, Mr. Abate, what we're trying to find is the precise language that tells bidders they need to submit a power of attorney for the consent of surety. It's not in sentence 1. We've got 2 more sentences. I want you to tell us where that is set forth here.
So the second sentence refers to the power of attorney setting forth the authority of the attorney, in fact, to assign the proposal bond or letter of surety on behalf of the surety company, and further certify that such power is in full force and effect as the date of the proposal bond or letter of surety. That sentence does not explicitly state the power of attorney has to grant authority to the to the attorney, in fact, to sign.
So we'll get to implicit, your position on implicit. Neither 1 or 2 expressly provide the direction that you're relying on now. So talk to us about sentence 3.
And before we get to sentence 3, sentence 2 is referring specifically to the proposal bond or the letter of surety.
And not to the consent to surety. That's correct.
So it's pretty explicit that sentence is not talking about the consent of surety.
So the question, as we see it, I will accept that this specification, these sentences the sentence I read standing alone does not explicitly say the power of attorney must apply to the consent to surety. We added that language later to ensure that this doesn't ever happen again. But when you look at the function of what the power of attorney is doing together with our
We want you to
form.
go through the language first
Okay.
that puts the bidders on notice. So it's not sentence 1, not sentence 2. What's your position on the third sentence?
Third sentence, consent to surety shall set forth the surety company's obligation to provide the contract bond upon award of the contract to the bidder. So the consent of surety, in order to be binding on behalf of the surety company, has to be signed by an attorney, in fact, having been conferred that authority by some legal instrument that can be shown to the Turnpike Authority at the time of bid submission that we can take based on that document alone, that the person who signed that document had the authority to do so.
And I thought that was your argument as to the first sentence as well, where it says each in a form acceptable to New Jersey Turnpike Authority, which shall be executed by the surety company. I thought that you were making an argument that when there is a discussion about a company executing a document, obviously companies themselves cannot execute things. So a person must execute a document on behalf of the company. And in order for the Turnpike Authority to know that that person has authority to execute the document on behalf of the company, there has to be some indication that that person was so authorized.
Yes, because in the realm of bid security, what happens in practice is we're not getting a bid bond or a surety instrument signed by the president of the company with a corporate seal and a notary. Frequently it's an insurance agent, a broker, some unidentified third party that signs these because it's within their line of authority on behalf of the principal. So in order for us to understand that the signature on that signature line is supported by something, we ask for a POA. Because under Meadowbrook and under the decisional law, we can't then go conduct an after the fact investigation and call up the surety company and say, can you provide us with the corporate resolution to confirm that Ms. Acosta had actual authority to sign this bond? I don't know who Catherine Acosta is. I still don't know. I could tell you that I Googled her. I think she works for an insurance agency, but that's not on the record. If you looked at the record, we have no idea who she is and whether she had the permission to sign this document. In fact, the power of attorney, an issue that is in the record, divests her of the authority to sign the consent of surety. It only grants her the authority to sign the proposal bond. And I think one of the problems.
You're referring to the power of attorney?
Yes.
Okay, so where in the power of attorney, direct me to where in this power of attorney form, it states that she's only authorized to sign with regard to the proposal bond.
Okay, I have to bring this a little closer because it's very tiny print, but it's two documents. The power of attorney form is really two legal instruments in one. The top half of the form is the power of attorney language itself, and beneath that, you can see there's a signature of Teresa Pistella, but in tiny print there, what you see at the bottom is really just an excerpt of a corporate resolution or excerpt from the bylaws of the surety company. So at the top of the form, all the way at the top, the header says, this power of attorney limits the acts of those named herein, and they have no authority to bind the company, except in the manner and to the extent herein stated. So right away at the top, we have language that says the individual signing the power of attorney or to whom the authority is granted only has that to which it is expressly delegated to them by the company. And when you look under the heading power of attorney, there's all this prefatory language, but it says the company does set forth, does hereby name, constitute, and appoint Catherine Acosta, Uniondale, New York, as its true and lawful attorney, in fact, with full power and authority conferred to sign, execute, and acknowledge the following surety bond. And then it references the surety bond number, that is the proposal bond. So,
and then it also states bond amount and then a line, and after bond amount, it says see bond form. Now, can you tell me what bond form that power of attorney is referencing? Is it the document marked as A24 entitled New Jersey Authority Proposal Bond, or is it referencing the document marked as A25 in the record entitled Bid Bond in accordance with contract specification? Or is it both?
It's only the proposal bond, because
the document marked New Jersey Turnpike Authority Proposal Bond.
Correct, because this may be self-evident, but only a proposal bond is a bond. A consent to surety is not a bond. The consent to surety is the commitment or the representation of the surety company that if the contract is awarded to El Sol, it will issue another bond, the performance bond, to guarantee 100% of performance of the contract. The proposal bond is only 10%. So the consent to surety is just a commitment or an undertaking of the surety to issue another bond. So this language, in our review of it, the authority rationally concluded that this does not refer to the consent to surety.
So that's referring to the proposal bond. Now, looking at the proposal bond, this is a form from the Turnpike Authority, correct? So I just want an understanding of what this proposal bond means or does, because it's a document that indicates midway through, signed this 24th day of June 2024. There is no signature on this page, though. There's no signature, but it seems to bind El Sol, Liberty Mutual as surety, and indicates on this proposal bond that if said proposal shall be accepted by the New Jersey Turnpike Authority, the principal shall duly execute the contract agreement and furnish the required contract bond within the stipulated time. So there's language in the proposal bond reference from the power of attorney binding Liberty Mutual to furnishing the contract bond. Would you agree with that?
What it says is that if El Sol is awarded
the contract,
but refuses to sign the contract or refuses to deliver the contract bond, then the bid bond, the proposal bond, is forfeited, which is 10% of the amount of their bid. So it's approximately $7 million. And it's intended as liquidated damages to secure the authority if it has to reject that bid as a result of El Sol's refusal to sign the contract or deliver the proposal bond and go to the next highest bidder.
I understand that Turnpike Authority's legitimate desire to have a commitment both for the 10% upfront and the balance of the amount on the contract once it's awarded. Could you structure a deal? Could your client structure a contract that does it in those two phases? You have to give us the 10% commitment with your bid proposal, and you have to be prepared to later, within days or so of the award of the bid, the contract guarantee the commitment for the remaining 90% of the funding. Not asking whether you think you did that, but could that be a logical turn of events?
As an alternative to having a consent to surety requirement, because in our view, the consent to surety, and there's a parallel process, it's mandatory under the local public contracts law by statute, but the consent to surety bridges the gap between the proposal bond and the contract bond, because in the time period between award of the contract and execution, and sometimes that could take 4 to 6 weeks.
Let me ask it differently. Is there anything that would prevent the Turnpike Authority from doing it in those two stages?
From if you're saying
give us the commitment for the 10% at the time you submit the bid with the appropriate surety, and upon award of the bid, give us the appropriate commitment, the appropriate surety for the balance that is due. Anything that would prevent the Turnpike Authority from doing so?
Not as a state agency, no, if we chose to do it that way.
So given that it's a theoretical possibility, what told the bidder in this case that they had to submit a power of attorney for both at the outset?
For both the consent to surety and the proposal bond.
Correct.
It gets back to my earlier point that if this court has said in Meadowbrook that if a consent to surety, if required, is a mandatory item that must be supplied at bid submission, how else are we to tell that that consent to surety was signed by somebody?
That begs the question that it was clear, and it was clear that it was required to be submitted at the time of bid submission. And that's what I'm asking you to tell us. Where does it say so? Where does the bidder know that's what's required?
Well, 102.08 says that there has to be a consent to surety submitted. And this court has said And it's been the law for 31 years that a consent to surety, if required, has to be submitted at the time of bid submission.
Again, I think we covered that third I think it's pretty clear from 102.08 that a consent to surety must be submitted. The question is, where in these 3 sentences would a bidder be on notice that they need to submit a separate power of attorney along with that consent to surety?
So
it sounds like you're arguing that they're one and the same, and obviously everyone should know that.
this is an issue that only arose. I'll answer that, but let me preface it by saying this is an issue that only arose with respect to Liberty Mutual. What occurs in every other time is you receive a generalized power of attorney that grants the agent authority to sign any and all undertakings. That's what happened with the other powers of attorney and bid security in this case, and it routinely happens. It's only in this case, in this instance, where the power of attorney and form in question circumscribed and limited the agent's authority. But if you go back to the consent to surety form itself, our consent to surety form at A4 in the record, the document itself has a line for the surety to sign. It has a line for witness attestation, and it has a line for the attorney in fact. In fact, Catherine Acosta, the designated limited agent on behalf of Liberty Mutual in this case, signed on the attorney in fact line. So any person looking at our consent to surety form would naturally recognize that attorney in fact means an individual possessing authority to sign on behalf of the surety company. And how would the Turnpike Authority know that unless there was a power of attorney to support it? And in this case, the person who signed as attorney in fact on this consent to surety didn't have the authority to sign the consent to surety.
I'm sorry.
Yeah, go ahead, Justice Hoffman.
Let's stay with that document for 1 second. So above that, it says Liberty Mutual Insurance Company, right? Could the CEO of Liberty Mutual have signed and executed a valid consent of surety at the time of bidding?
If he signed it and there was a title and it was notarized, or there was something evidencing that signature was authentic, I can't speak for the client, but I would imagine that would be, as a legal principle, acceptable.
Okay, so you're not saying that you have to have a power of attorney that extends to the consent of surety. I hear you saying you have to have a valid consent of surety. Am I wrong on that?
You have to have a valid consent to surety.
You're not saying there must be a power of attorney. You're saying there must be a valid consent of surety, right?
I think that's going to first principles. Yes, that's the foundation of all of this whole discussion. Yes.
So if you're saying if you're saying, just to repeat myself, that there must be a valid consent of surety, that doesn't necessarily mean there has to be a power of attorney that attaches, because you could have the CEO of Liberty Mutual sign it, and we wouldn't be here, right? If the CEO of Liberty Mutual had signed this, had executed this, we wouldn't be in this position, right?
If the president CEO crossed out attorney in fact and wrote president and CEO, and there was a seal of the corporate secretary of the company,
there's a surety line. Why would the president have to cross out attorney in fact? Why couldn't the president have just signed under this surety line?
Well, I mean, attorney in fact is I guess a legal term of art under the statute, like, governing powers of attorney. But other than that, I guess one could, if there were some indicia that's as to the authenticity of the signature, then that would be acceptable. But if you're going to have a third party and some unidentified person sign this document, and you include a POA that disclaims her authority to sign the consent to surety, I think that there is an inexorable result that flows from that.
So your point is, if you are going to have a power of attorney, then that power of attorney must accurately and validly extend to the consent of surety, right?
I think we're arguing a little bit more, but your suggestion, Justice Hoffman, is a more limited take on the normative principle of law that we're espousing here. So, but in this case, yes, on the specific facts of this case, yes, I agree with that.
Can we go back to the proposal bond form? Because I'm still not clear. With
Yes,
regard to this form. So you indicated that this, I think you answered my question earlier that this was in the event that the bid wasn't accepted. I'm not sure. Do you have that form before you or no?
the proposal bond form.
Yes.
At 824 of the
Yes,
record.
at 824. So I just want to understand, what is the significance of the B paragraph? The B paragraph on the proposal bond refers to the contract bond. Now, correct me if I'm wrong, but it's my understanding that the contract bond refers to the consent of surety. Is that
No,
right?
The contract, the consent to surety is the surety's representation that it will deliver the contract bond when the contract is signed.
Right. So in B, paragraph B, it states, if said proposal shall be accepted by the New Jersey Turnpike Authority. So to me, that means if the bid is accepted and the principal shall execute the contract agreement and furnish the required contract bonds. This paragraph seems to be referring to an agreement that the contract bond will be, that the consent of surety will furnish the contract bond for the 100% at the time that the bid is accepted. Is that correct? If not, please explain what that paragraph means.
Okay. The proposal bond is a guarantee by the surety company that if the awardee doesn't deliver the performance bond or the contract bond, I'm sorry, because sometimes like these terms get used interchangeably and it can
Right,
get
and that's what I want to
confusing.
make clear what is being discussed in this form.
So it's the surety's representation that if the awardee does not produce the performance or contract bond at the time of execution of the contract, the face amount of the proposal bond is forfeited. The amount of that bond is limited to 10% of the bid. Here, $70 million. So it's a $7 million penal sum.
And
If-
the contract bond is how much?
The contract bond is 100% of the bid, so it's $70 million. So
You're saying that this document says if the 70 million is not paid, then the Liberty forfeits the 7 million.
correct, and the purpose of that is to provide some measure of coverage for the Turnpike Authority if it has to go to the next lowest bidder. However, it doesn't fully protect to the same extent as a consent to surety because here the bid spread is $10 million. The next bid is $80 million. So forfeiture of the proposal bond, no consent to surety, no contract bond gets us $7 million, but we still have a $3 million gap. And whether or not the proposal bond covers the bid spread is obviously a function of what the bids are. And it doesn't always provide complete security. That's why contracting agencies most times will require consent to surety because it's another level of bid security that contains a representation of the surety that, yes, we will give you the 100% bond 4 to 6 weeks from now when all the paperwork is ready and we're time to collect the insurance certificates and sign the contract.
And the
You
consent of
explain-
surety is not a bond in and of itself.
No,
Consent of surety is a guarantee that if awarded the contract, you will execute a contract bond for the entire amount. And then the proposal bond goes away, right?
correct, yes.
So on the power of attorney form, when it references a bond, it says, uses the word the following, right? It will authorize the following. It can't be referencing the consent of surety because the consent of surety is not a bond, right?
That's right. The triggering event for return of the proposal bond is execution of the contract and handing over the contract or performance bond in the amount of 100% of the price.
So you're saying they only have to submit the 7 million as a placeholder for the 70 million. And then once all the contract documents are signed, the contract is awarded, then they just submit the 70 million and the 7 million goes away.
Right. The bonds are voided or returned to the bidders. Everybody submits a proposal bond. We award to El Sol or Cinzeri, whoever turns out winning here, you return the bonds. And then at the time that it's replaced by the contractor performance.
So
bond.
that's what this form is saying. If the proposal is rejected, that or in the alternative, if the proposal is accepted, this obligation is then void, meaning the proposal bond is void. But it seems as though the parties, Liberty Mutual, agrees in this proposal bond that they would furnish the required contract bond at the time the bid is accepted.
Right. So
This
Sorry, I
form,
thought you
Liberty,
had disagreed with that before.
maybe I misheard.
okay. So it seems as though in this form that it says, we, the undersigned, LSOL Contracting, LSOL Liberty Mutual as surety. It's referring to the undersigned, but again, there's no signature on this form. So I'm not sure if this is the entire form that we have, but there's no signatures on this form. But it's referring to, we, the undersigned, agree to everything that's in here, including that if the proposal is accepted, the principal shall execute the contract agreement and furnish the required contract bond. Is that an agreement by LSOL and Liberty Mutual that they will furnish the contract bond at the time the bid is accepted?
No. Just to answer your prefatory question. So the second page, A25, there's a signature. It's these documents, the proposal bond and the signature are submitted electronically through a third-party software. So there's like this fill in the blanks form on the second page, and that contains an electronic.
So that's the signature that's being referred to on A24.
So, but
Okay, which is why I had asked initially, is that form that's being referred to from the POA A24 or A25 or both?
I'm sorry, I must have
Because
it refers
A24,
to those two pages collectively, but not A26, which is the another copy of the consent to surety. It only refers to the proposal bond. But to get to your substantive question, if you read I won't read it out here to the court like at length, but if you read this document in its entirety, the function of it and what this paragraph B is saying in full
Could
context.
you just give us an appendix reference for that, just to make sure we understand which document you're
I'm
looking
referring to A24.
at? A24, thank you.
What it's saying is, if the proposal is accepted and if the principal executes the contract document and furnishes the bond within the stipulated time, then this document goes away. If they don't do it, the penal sum, the 10% of bid, is forfeited. The operative language, though, doesn't obligate the surety to deliver that performance or contract bond. It's simply saying, if everything is accepted and that bond is ultimately provided, this becomes invalid. If it's void, because it's moot. They've performed, they've signed the bond, they're fully obligated, they signed the contract.
And if everything is not delivered, then the $7 million is forfeited.
Correct.
But that's the only purpose of the proposal bond, to state this has no purpose at all if the contract bond is ultimately signed. If the contract bond is not ultimately signed, this $7 million is lost.
Correct.
And goes to the Turnpike Authority.
Correct. And the proposal bond would protect the authority if the next lowest responsible and responsive bidder is within 10% of the ostensible low bidder's bid. But if there's a greater spread, then there's a gap there. So the consent to surety requirement operates to provide an additional security in those situations to confirm that the contract bond will be delivered. And in major infrastructure projects like the Turnpike Authority undertakes, you could be talking tens or hundreds of millions of dollars. This contract itself is actually a relatively small contract for the Turnpike. It's 70 or 80 million dollars, depending on what this court's ruling is. But we could easily have contracts. We have one right now that's well over $1 billion that may ultimately wind up back here. But our biggest procurement in history is $1 billion plus. And so the integrity of these bonds becomes very, very important. And the proposal bond doesn't always fully secure us. That's why we require a consent to surety to confirm that, yes, we're ultimately we'll release the other bidders, we're going to get the bond, and we're absolutely secure that there's no gamesmanship or wiggling out of this bid.
I just wanted to have an understanding of what it was that was being referred to from the power of attorney form, because the power of attorney form, if it's incorporating another form by reference, that might give Acosta more authority and power. I want to have an understanding of that. So just to be clear, it's both these pages, A24 and A25 together, that is being cross-referenced from the power of attorney form.
That's the bond being referenced here. And if you read below on the power of attorney form on A3, the bottom third of the page is an excerpt of the corporate bylaws, and it does grant to a corporate official, Dennis Carey, in Article 4, it says that the officers of the company can appoint attorneys in fact as may be necessary to make, seal, execute, and deliver a surety any and all undertakings, bonds, recognizances, and other surety obligations. So there's a larger class of instruments or legal instruments that a power of attorney can be delegated the authority to execute on behalf of the company. But in the operative power of attorney language at the top of this form, there's a disclaimer, and Ms. Acosta was only granted authority to sign the bond, the proposal bond. And since a consent to surety is not a bond, by implication, this language excludes her from having the authority to sign the consent to surety here.
At what point do you release the other bidders?
Typically, there's a recommendation to the board. The board will approve. The minutes get certified, sent to the governor's office. On by statute, the governor has a 10-day veto period before any action of the authority can be accepted. And then the contract documents are assembled, the necessary documents are collected, whatever other additional information is needed. And then at the time of execution, the contract is signed. There could be a lag, like I said before, 4 to 6 weeks. And at that point, it's done and everything is returned and released.
And does all of that take place after the bid is accepted?
Those are all ministerial acts that take place after the bid opening and after it's accepted by the board.
I know you've talked to us about the loss to the Turnpike Authority in this case because of the $10 million difference between the lowest bidder and the next bidder. And the security and the proposal bond only having a 10%, $7 million coverage for you. But El Sol never got the bid. It was never awarded the bid. So how did the Turnpike Authority lose money in this case?
El Sol, Cinzari was awarded the bid, and there was a stay imposed, and then the appellate division ordered us to award the bid to El Sol. So we rescinded that award. The present state of affairs is that they've been awarded the bid, but it hasn't been implemented because we're in the middle of this.
But short of the litigation, by not awarding the bid, you're not releasing to El Sol, you're not releasing the other bidders.
I don't want to speak out of turn. I'd have to check with the Turnpike Authority as to whether the physical bid security has been returned or voided yet. I don't know the answer to that. I could find out and let the court know after argument, but I'm not aware of the answer to that.
No need to submit on that.
Okay.
And your argument wasn't that the Turnpike Authority lost $3 million in this specific case. It was that the reason that the COS needs to come from a person with authority to bind the surety company is because in many cases, there could be a huge difference between what the Turnpike Authority stands to lose if they get to keep the performance bond, but never get the contract bond and then need to go to the second lowest bidder. It could be, a lot more than the amount they got in the performance bond.
Yes, that's right. I mean, the spread here is 10 million. At the high end, off the top of my head, some of these bids were over 100 million. So yes, we went from 70 million for El Sol to 80 million for Cinzari, but it could just as well have been 100 million to the next lowest bidder. But what we're adhering to is the principles laid down in the case law over decades. Nobody's saying that that Liberty Mutual or El Sol in a subjective way are untrustworthy and not going to deliver the bonds. But these are the procedures that have been laid out in the case law that we are obligated to adhere to ensure procedural fairness and openness and confidence in the public.
You've changed 102.08 in a way that this issue that we're discussing today is unlikely to resurface, correct?
It's unlikely. Yeah, well,
you've revised the language and made it crystal clear in the revised language what's required.
We did. Yes. as a result of this whole situation, the Turnpike Authority went back and amended the specification to make absolutely certain that there are no further misunderstandings. So
Are there other matters like the El Sol dispute that is in front of us that predate the August 2024 change?
none that have ever come before this court, because usually these are addressed based on the case law. If there's any ambiguity or uncertainty with respect to the bid security, any irregular language, and it does happen from time to time. I mean, I've litigated a number of these cases. You would think that surety companies and their agents would have figured out the law in 31 years, but it happens fairly often that the bid security or the proposal bond has equivocal language, and it gets thrown out, and that's the end of it. Usually it gets resolved in the law division, and maybe
Even
to the appellate
if there are
division.
no disputes other than this one that have arrived in this room, are there other disputes arising from this language out there?
None pending in the Turnpike Authority, to my knowledge. The problem is that the way the lower court issued its opinion, it seemingly cracks the door open and presents an opportunity for bidders in the future to say that if there's an irregularity or defect in the bid security, that it's waivable. And I don't think that that's what the case law stands for, but I have an unpublished appellate division decision now that says something different than what Meadowbrook said. And so the next time this occurs,
Meadowbrook was dealing with the complete absence of consent to surety. Am I right about that?
yes,
It just simply was not submitted.
yes, that's right.
So while I understand why you're and respect that you're relying on Meadowbrook, its general principles as to the components of what a successful bid should be, the more nuanced issue we have here, which is not the absence of a consent of surety. There was a consent of surety here, but the Acosta's authority to sign both documents as opposed to one. Meadowbrook really was not dealing with an issue quite that nuanced. Am I correct?
That's correct. So the power of attorney issue, we certainly searched high and low in the case law, and it has never quite come up in this context. So the power of attorney issue is either subsumed within the holding of Meadowbrook, or it's a logical extension of the court's holding. However one wants to view it, it's within that the central holding of that case.
Counsel, I understand that you're authorized to give the contract to the lowest responsible bidder. At what point are the bidders found responsible? At what point do they check that box? And were all 5 bidders in this for this contract found to be responsible?
It's reviewed by the purchasing department. It's reviewed by in this case, the engineer. It's an engineering contract, construction contract.
So were all 5 bidders in this contract found to be responsible bidders?
I'm not sure if literally everyone was. We looked at 1 and 2, and we didn't go beyond that because actually it may be in the agenda item, the board resolution that's in the record. Typically the recommendation from the law department to the board to approve will include a tally of responsive bidders and the numbers.
Responsible, right? It's the lowest responsible bidder, right?
Yeah.
So we're both Sansari and El Sol found to check that responsible bidder box?
No, the recommendation, and I could look it up. I don't recall the appendix reference off the top of my head, but the agenda item, the recommendation to the board recites the list of bidders and the amounts, and it says that although El Sol bid $70 million, which is lower than Sansari, it was deemed non-responsive due to the defect with the consent to surety and power of attorney. And therefore, the lowest responsive bidder is number 2, Sansari. That was that's ultimately the determination of the agency that was protested by El Sol that lands us here.
Other questions, anyone? Anything you'd like to add at this point? We'll have you back for rebuttal.
I don't think I'll need it since this court's questioning is so detailed, but I'm
not asking you to waive it now.
Thank you, Your Honor.
Thank you, Justice. Mr. McKenna.
Thank you, Justice. First, I want to say how honored and humbled I am to be here. I think I graduated law school in May of 1980, and I've had the honor of being in front of other Supreme Courts, but this is my first time getting the honor of actually doing oral argument in front of you all. I've had the privilege, Justice signed, two of his kids worked with me, Justice Clifford, several of his clerks worked with me, but this is just to me a great honor. And that's something any attorney strives to be, is to be here in front of all of you. And I really appreciate that. I'm here today on behalf of El Sol. One of the things I'd like to do is to kind of bring some reality to this, in that on January 28th, El Sol was awarded this contract. They were awarded this contract. Shortly thereafter, the performance bond in question for the full $70 million was delivered to the New Jersey Turnpike. The award and the bond are sitting with the New Jersey Turnpike. As counsel said, normally 4 or 6 weeks. I don't believe it's that much. The project should have a notice to proceed and the work should have started. It has not. Despite the fact that New Jersey Turnpike came here and asked this court for a motion to stay, which was denied. New Jersey Turnpike Authority, on its administrative prerogative, has decided that it's not going to award this project, despite the denial in this court of a motion to stay. And now they've also filed a motion for reconsideration that was out of time for the court to reconsider that motion to stay.
So that issue is still before the court.
Yes, it is.
Let's come back to the core dispute at the beginning of the process.
Right.
That's the basis for the petition for certification. Please go ahead.
And with regard to that, the comments here, one of the things that's difficult is NJTA is trying to parse out A24, A25, and A26. That's not the real world. The real world is all three of those documents come in one package together. The proposal bond, the power of attorney, and the consent of surety all come together in one package. They are not three separate packages. They are one package. And as far as Liberty Mutual was concerned, the consent of surety that they issued, that is the second of the 3 pages, applied to both the first page, A24, and also applied to A26. And in keeping with that, on the consent of surety, it has the bond number for which the Ms. Acosta was given the authority. So it's always been Liberty Mutual's understanding that this process, which started when Surety 2000 came into play, this electronic filing of these papers, that this was the way that they'd come in as a unified set of 3 documents, one being the bid proposal, the second being the power of attorney, and the third being the consent of surety. New Jersey Turnpike is trying to parse them out into 3 separate documents. They're not. They were one document submitted at the same time to the authority.
So the standard 102.08 and the third sentence appears to cover the surety for the entire contract because it speaks to the company's obligation to provide the contract award. Agree? How did you guarantee that at the time of your bid submission?
Well, we guaranteed it actually several ways. As pointed out, the bid proposal bond itself says that Liberty Mutual is going to award, and if El Sol is given the contract, that Liberty Mutual will issue the performance bond that is required. It says it right in that bid proposal. And then the consent of surety goes on, and Ms. Acosta signs that as the attorney based upon the power of attorney. That was the second page.
If the consent of surety is signed by someone who lacks the authority, is it the equivalent of having no consent of surety altogether?
No. Well, one, we do not believe it is, Your Honor. Again, We're trying to parse these things out into three different documents. They are one unitary document that needs to be taken and considered in the way that it was put forward to the Turnpike. And that Ms. Acosta, one, was the attorney, in fact, was given under the power of attorney. And this parsing of the bid bond and saying that the power of attorney only applies to the bid proposal is not the intent of Liberty Mutual. It was to be for all of the documents that were attached to it.
The power of attorney itself specifically refers to this bond that ends in 2021. That's the proposal bond.
Yes.
How does it extend beyond that?
The consent of surety says that up in the top right corner, it has the bond number that the power of attorney applies to. It's SN something up in the corner up there
On which document, counsel?
on 826. Up in the upper corner, there is a number there. That is the
You're referring
referring
to
to A4?
SNJ 05303-62021? You're talking about a specific number?
yes, that number up in the corner. These documents came as a package of three.
And this is the consent of surety.
Correct.
And is that A4 you're referring to as A26? Is that?
Okay, I'm
A4?
sorry, I'm not sure exactly what the reference is.
Okay.
But whatever is the consent of surety, these all came as a unitary package. And that up in the corner there, it has that same bond number to which the power of attorney specifically says it applies.
You've said that a couple of times. Can I just ask a practical question? How were these forms generated? Are you saying you received them as a packet? Does that mean that once you are asking to be a bidder, you receive a packet from NJTA with the
No,
forms included?
What happens here, and has happened more than 200 other times throughout New Jersey, in front of the New Jersey Department of Transportation, in front of New Jersey Transit. Remember, this is the one and only time anyone has ever questioned this process. It's a process that's gone on hundreds of times without any issue, without any problems. And indeed, when it was finally cleared, this one went through without any issues and any problems.
Can you clarify one other thing? The bond number that ends in 2021 guarantees a specific dollar amount.
Yes.
That's 7 million? Or
No,
70
20,
million?
it guarantees the contract bid amount, which was 70 some odd $million.
Sorry,
no
so you're
contract.
saying that the surety bond is not the performance bond, it is the contract bond?
Again, semantics, I always look at the bonds as a bid proposal bond, and then there's a performance and payment bond. The
Okay.
performance and payment bonds are normally in what they call the penal sum, and the penal sum is the contract amount. That's the way that I look at it.
Is the bond in the record?
Is, no,
2021?
the bond was already now given to New Jersey Turnpike after the award. You had to wait for the award.
Is the document itself in the record that would show precisely the dollar amount that is guaranteed? Is that in the record?
That document is not in the record because it didn't exist until the beginning of February of this year.
After the
that-
appellate division's
But I think
decision.
that's the Turnpike Authority's point where they say, the POA says Catherine Acosta, as its true and lawful attorney in fact with full power, hereby constitutes and appoints Catherine Acosta as its true and lawful attorney in fact with full power and authority hereby conferred to sign, execute, and acknowledge the following surety bond. But the only bond that was submitted at that point was for $7 million, not $70 million.
Correct. And that if you look
correct?
at the bid proposal, that the bid proposal bond in its language specifically says that it'll be put in, the bond will be in the contract amount. And the contract amount was 70 some odd $1 million. And 10% of it was the upfront bid proposal guarantee.
Just
So
take us
there's
to-
two, sorry, you said there's two bonds. You call them different things than the Turnpike Authority. You said there's a bid proposal bond and a performance bond, correct? Are you agreeing that at the time of the bid, only the bid proposal bond was submitted?
Yes, I agree.
Okay, and so based on that, I think what the Turnpike is arguing is the power of attorney form is specifically referring to what you're calling the bid proposal form, which was the only sorry, the bid proposal bond, which was the only bond submitted at the time.
It
You agree
it
with
was
that?
referring both to that and to the other document that was attached to it,
And you're
which
saying-
was the consent of surety.
And you're
Correct,
saying
but-
because the consent of surety has the number on the top right-hand corner, then that means it's also referring to the consent of surety? But isn't that, how are these numbers generated? It seems like these are all electronic forms. Is
Yes.
it logical to conclude that that number is just a number that the New Jersey Turnpike Authority uses to reference this particular bid?
No, because if you look at the power of attorney, it's that same number. In other words, on the power of attorney, it says we are giving the authority as to this bond number, and it's the SN number. And that
Right.
same number is on the consent of
And
surety.
how does it get on the consent of surety? Like, how
The
did that SN number
Liberty
ending in
Mutual-
2021? end
Liberty
up there?
Mutual puts that on it. These are documents generated by Liberty Mutual.
But either way, sorry, isn't all the number, the only bond submitted is for 7 million, not 70 million?
Correct.
So how could the consent of surety possibly bind Liberty Mutual to the 70 million, which hadn't been submitted yet, if it wasn't signed by someone with authority to bind Liberty? I think that's the Turnpike Authority's point, that the consent of surety itself says this power, the POA itself says this power of attorney limits the acts of those named herein, and they have no authority to bind Liberty except in the matter and to the extent herein stated. And so the only manner and extent herein stated was for the $7 million, what you call bid proposal bond, not the $70 million performance bond. So they don't have anything saying, and we are also bound to the 70 million performance bond.
Yes, they do, because the bid proposal bond in and of itself says they will issue the bond if the contract is awarded.
So the $7 million bond itself is also the $70 million bond?
I'm sorry, the bid proposal bond says in it that they will not only, here's our $7 million should they not do it, but we are also going to enter into a bond for the full contract amount is stated in the proposal bond.
So just let me make sure I understand your argument. You're saying that Acosta, by being given the power of attorney to sign the proposal bond, committed Liberty Mutual to sign the contract bond later because of the language in the proposal bond.
Yes,
And what language is that?
And please give us the record number, the A number.
A24.
What's the language?
It is the paragraph, subparagraph B. In this, the document for which there is no disagreement, there is a proper power of attorney, but it says, if said proposal shall be accepted by the New Jersey Turnpike Authority, and the principal shall duly execute the contract agreement and furnish the required bond within the stipulated time.
Yeah, but that to me, that says if the contract is signed and if El Sol submits the $70 million bond. It doesn't say if the contract is signed, no matter Liberty agrees to submit a $70 million bond.
But El Sol never submits a bond. It's Liberty Mutual that submits a bond.
Correct, but sorry, so then I apologize. To me, it reads as if the contract is signed and if Liberty Mutual submits a bond, not if the contract is signed, then Liberty Mutual will deliver a bond. Can you read it one more time?
Sure. It says, if said proposal shall be accepted by the New Jersey Turnpike Authority and the principal shall duly execute the contract agreement and furnish the required contract bond within the stipulated time. These are all the prefaces as to why then they get off the hook. So
The
this is
performance bond.
for the proposal bond.
Right. So I think then the Turnpike's argument is all this is saying is if El Sol gets the contract and Liberty Mutual submits the $70 million bond, then the $7 million bond goes away.
Correct.
It does not say if El Sol gets the contract, then Liberty Mutual is obligated to provide the $70 million bond. That's what the disagreement seems to be over.
I can see your point. I don't read it that way personally. I see this as them saying, I mean, to me, part of this is we're putting ourselves into a utopian world, some world here that things, or dystopian, that like there's never been a situation I'm aware of, and I've been doing this for 45 years, where a bonding company walked away from a bid proposal bond. Not one in 45 years.
Counselor, if I could just clarify, is it your position that the proposal form, that A24, is a validly executed consent of surety in a form acceptable to the authority?
No, I'm saying it is here, but the consent of surety, one, I agree with the argument that it did not require a separate power of attorney per the language. That is made plain by the fact that the Turnpike Authority thereafter, on its own, changed the language to make it very plain that they needed to have a power of attorney with regard to the consent of surety.
So just to clarify, so your point is that when you said no, that means A24 is not a validly executed consent of surety.
A24 is not a validly consented. I totally agree, Your Honor. The difficulty here is we keep on trying to take what is meant to be three documents to be read together and trying to parse them out in this way. That 13 times prior to this, there've been no issue. 200 times.
Let's leave for a second. Let's focus on the documents here. Is it your argument that although A24 is not a validly executed consent of surety itself, that it obligates Liberty Mutual to execute a consent of surety?
Yes. No, it obligates them to issue the performance bond, which is essentially the same thing that the consent of surety does.
So even though you're saying that the document as to which Acosta indisputably had authority under the power of attorney to sign had the same impact on the obligations of Liberty Mutual as a consent of surety?
In the way that the world works, yes.
And why is
that there was never been, and no case has been brought to this court that says, okay, once a valid bid proposal bond had been executed, that one time in the United States history that a surety walked away and didn't give the performance bond. So, it's all part and parcel of a process.
So the paragraph after paragraph B in the proposal bond form says that there's an initial sentence, then this obligation shall be void, meaning the proposal bond, the $7 million. Otherwise, the same shall remain in full force and effect, it being expressly understood and agreed that the liability of the surety for any and all claims hereunder shall in no event exceed the amount of this obligation as herein stated. What obligation is that referring to on the proposal?
That is referring to the $7 million bond, I believe.
So not the contract bond for the
No, it's not. Again, we get into this because we're trying to parse these things out into different pieces, and they're really one whole.
But when that's signed, at the moment that's signed, was there any document in this trio of documents that you're focusing on here that indisputably put Liberty Mutual on the hook for $70 million at that moment?
No. There wasn't anything other than the past practices, the way that the world works and everything else. If we now have ourselves and we now take ourselves and say, okay, we're going into this closet here and we're going to forget about everything else and how everything else works.
And I understand that obviously a surety has to consider its reputation, and a significant issue like this doesn't help that if it happens. But just to be clear, because I think you don't contest that what Meadowbrook says is there must be a binding consent of surety, that there is something of a gap here in the actual written contractual language of these documents, that you're arguing past practice and the way the industry works in reality makes it a meaningless gap, but it does appear to be a gap between the authority granted to Acosta and the Liberty Mutual's obligation to come up with $70 million in case everything went south.
Justice Patterson, I believe someone could take a sharp knife and try and put that in there and
What do you
try and
mean?
wedge that knife in there. Again, as far as Liberty Mutual was concerned, they, in giving that power of attorney, that they looked at it, it was the power of attorney not only for the bid proposal, but the power of attorney for the consent of surety.
But
And that was stated immediately thereafter.
But they're not New Jersey Turnpike Authority. They may have, I have no idea. They may have a practice that in their own company that commits it to meet these obligations based upon that language. But as I perceive the issue that we have is whether or not, as a matter of contract law, the documents pieced together and looking at them, I agree with you, as a trio of documents obligated Liberty Mutual in the event that this entire project somehow went off the rails to pay $70 million.
I would say yes, if you want to, again, devoid yourself as to what had happened 13 times prior to this, what had happened 200 plus times prior to this. If we can now believe that the way public bidding is a game and we got to go for a gotcha and say, okay, you know what? What if we thought this and this?
All understood, but am I wrong to?
No, you're not.
To
You're
conclude
not.
that our issue here is whether or not the bid was defective.
Correct.
And there are a lot of considerations that go into that, including the bid language and the language of the.
I can, I
POA.
can understand the justices sitting here around and looking at it and saying, well, Mike, there is this question here as to this power of attorney on the consent of surety.
Let's say Liberty, we can't, it's hypothetical, but let's say Liberty Mutual had decided we really didn't, we intended on that day to obligate ourselves to 7 million. That's plenty of money. 7 million, something else to follow, other documents to follow, and actually litigated that position. Can you tell us whether they would have prevailed had they tried to get out from under?
They would have lost horribly.
They would have.
Because of the fact that they had done 12 times, 13 times prior to this, they had done that. 200 plus times they had done that. They would be equitably stopped, whatever you would want to say, that they wouldn't be able to come up here in front of any of you and say, you know what, we've done it 220 times before this, but now we are making a different interpretation.
I understand, and I completely understand that I'm not suggesting they would do that, but I think the core question before us is the language with this power of attorney and what appear to be some limitations binding on them or not? And what impact does that have?
And I understand that. And again, it's what is public bidding supposed to be? Public bidding is supposed to be prevent against extravagance. The fact is, we're here, New Jersey Turnpike could have El Sol out there working on the job 3 weeks ago, 4 weeks ago, have this important project actually proceeding. They have stopped it. They are here looking for this court to bless them to give $10 million to a second bidder based upon the sharp edge of a knife that they're trying to put in here between that power of attorney and its significance. And I don't think that's what the law is supposed to be about.
So their argument in essence is you're only on the hook for 7 million at the outset, not the full 70 million. And the standard required a consent of surety for the contract bond at the time of the bid proposal. How do you get around that?
Well, I get around it in that the past practices and the way it's been done doesn't support that at all. And the fact is, it's not a game of gotcha. And the fact is, that's what it's trying to be made into. Is okay, well, this power of attorney here, okay, they say it was a mistake. It wasn't a mistake. For the 13 times prior to this that it was accepted. It was the normal practice that things would go this way. And they are finding now a nuance, a concern. And I think the concern is no more different than the case in the Greenwood case, that this concern is not bared out. In the Greenwood case, which I find to be very interesting, they look at whether or not there was a concern as to whether or not the police officer could lose his other eyesight. And in that court, and I really think it's something we need to look at here respectfully, is the court said, well, let's look what happened. What happened when he was at the academy? Were there any issues when he was at the academy? No, there was no issues. Okay, why then is this concern raised to the point that now we're not going to allow this state trooper to go on and to be a state trooper? Is that there isn't enough validity to that concern.
Counselor, doesn't Meadowbrook say that a valid consent of surety is more than just an immaterial gotcha?
Oh, I agree with you, but we're not talking about, there is a consent of surety here. So if anything, it's more like the Blue Diamond case where the consent of surety was looked at and the fact is the court said, no, we're going to go ahead and we're going to make the award. This isn't a situation that there isn't a consent of surety. What we're looking at is whether or not, as to that power of attorney, when it said bond such and such, and we're going to forget that these three documents all came in together, and we're going to somehow look at this last document onto itself and say, okay, the power of attorney only applied to the bid proposal. If it said in that power of attorney, it only applied to the bid proposal, I totally agree with you. I understand exactly where everybody's coming from. That's not what it says. It says it applies to bond such and such. And if you look up in the upper corner, that same bond number is up there on the consent of surety.
The consent of surety is not a bond.
The consent of surety is not a bond.
So the power of attorney says it only applies to quote unquote the following bond, right? It's a language. This power of attorney only applies to the following bond. By that language, it can't apply to a consent of surety.
Yes, it can, because it was put in as a unitary document. And I understand where your honor is coming from as to this. I just think that we're trying to parse these things out into such small things. And I agree that a bid bond is a very important thing, and Meadowbrook is a very important concept of law in New Jersey.
Let me just ask you which of two theories, or maybe both, you're promoting. Are you saying that we should look at all three documents together and there was a consent of surety that's valid that ended up being executed in the end? Or are you saying that by authorizing Acosta to sign off on the proposal bond, which in turn obligated Liberty Mutual to take that next step in the event of an award of issuing the contract bond, Acosta implicitly or by inference committed Liberty Mutual to the entire 70 million?
Justice Patterson, I believe I'm saying both. I believe that they're one and the same. And it's when we now start trying to parse these things out that it gets into these other arguments.
So just going back to the number, that the surety bond number that was placed in the power of attorney. So just so I understand, I know these are electronically generated documents, but you're arguing that SN number that was generated by El Sol or Liberty Mutual. Okay, so Liberty Mutual generates that number. And because I think you're arguing because Liberty Mutual, in giving Catherine Acosta the authority to sign this power of attorney, placed the surety bond number on the power of attorney form, on the proposal bond, and also on the consent of surety. And by virtue of that, that was Liberty Mutual's indication that Catherine Acosta had power of attorney to sign the consent of surety?
Correct. If you look at the power of attorney, which is A27, it says that this is all granting her the power with regard to surety bond number SNJ 06 303 62021. And if you look at the consent of surety up in the top corner, It says SNJ 05303622021.
But was that
They believed
reference-
it.
Was that a reference to the proposal bond number, the 7 million?
That's the
Or-
proposal. To them, they looked at this as a package. They looked at it as three documents that were being sent through the Surety 2000 electronically.
I understand that. And I thought I heard different answers, so I'm asking you to clarify. SN 2021
Right.
has a number on it,
Yes.
7 million or 70 million?
That number on it would be 7 million. But it's also at the same time saying that if you give them the award, we will give you the 70 million. It's both.
Will there be a contract bond eventually that also carries that number? If this had gone through?
It actually, it doesn't, the numbers are generated when they actually give out the bond. They're generated differently. The bond that they have, New Jersey Turnpike has this moment, is for the full $70 million.
Does it have the
They
same
have-
number on it? Or a
It
different
doesn't
number?
have that, the number on the bond is based upon the year, and it's not based upon this number.
And the
This
answer,
was the Liberty Mutual's number assigned to this bid submittal package.
and the answer to the chief's question about the number being, and your answer being both, is based on past practices.
Correct, as well as the statement in here that if the award is made, that there's going to be a bond issued in the full amount of the contract.
That's paragraph B.
Yes,
So let me just follow up on that. The bid package has this 2021 number, including all of the documents, the trio of documents you're suggesting that are submitted as part of the bid package. And in essence, following the regulations as they were at the time that this bid package was submitted, correct?
correct.
So if this had gone on beyond that, there'd be another package after the contract was signed that would include the contract bond, which might have a different number because it's a different package.
Correct, and that's the one that they do have right now because there's been an award and that bond has actually physically been given to the Turnpike Authority.
So how
Then
does,
replaces the proposal bond and makes that
Correct.
null and void.
so how does the number help you?
That number helps me in that it shows that the intent of it was that this was three pieces of paper being put together and that it wasn't the intent of Liberty Mutual in signing that power of attorney that it was going to somehow make the consent of surety a separate document onto itself. It didn't come as two documents in one document. It came as three documents, and Liberty Mutual looked at it that Ms. Acosta was given the authority to sign A20, A24 and A26 through the power of attorney, which is A27.
But both of those apply to a bid, to a number that I think there's no disagreement, only puts Liberty Mutual on the hook for 7 million, not 70.
It put him in for both pragmatically. It put him in, to me, the bid proposal says they're going to award they're going to issue the bond if there is an award to El Sol. So to me, it puts them on the hook for that too.
Counsel, are you saying that if the consent of surety had been sent by a different office at a different time, you'd have a materially weaker argument?
Yes, I do. Because it would not be part of that package. It wouldn't have a separate power of attorney to attach to it. And that it's now we're trying to, again, if you look at it, we're all looking at that language as to surety bond number SN. What does that mean? NJ Transit is the New Turnpike Authority saying, well, that means only the bond bid proposal. Liberty Mutual saying, no, that is for all the documents we submitted as part of this package. And it doesn't specifically say in here, bid proposal. So that's the difference is, as far as Liberty Mutual is concerned, Ms. Acosta was given the power of attorney to sign the consent of surety. I understand all of the erudite arguments that we start to go into as to saying, but that's the reality of the world is that these bids go in all the time, 13 times prior to this. And even when this one here was awarded, the way that bid protests happen is almost immediately there's a protest submitted that day. That didn't happen here. After the bid was done, El Sol went over to New Jersey Turnpike, met with the New Jersey Turnpike, met with the designer, had a conversations about the project. They were told they were going to get the award.
But you're
They-
not arguing that they were entitled to get the
Oh,
award based
no,
on
I'm not.
somebody's
I'm not in the
comment.
least.
It's a very technical world that you have practiced in for
I
many decades.
totally understand that.
Yeah, and I doubt you're probably not going to tell a client you're good because they said something.
No, I'm
you're
not.
sure.
But the fact is, somebody then came up, how this concern got invented here or found or has always been somewhat of a intellectual curiosity to me as to.
Does it for our purposes, for what this court is being asked to decide, how it happens is a lot less important than the question whether this became a defective bid and that her power of attorney fell short of what Liberty Mutual had to give her in a power of attorney.
But you'd
I right
also
about
be
that?
saying that there's 220 other projects out there that suffer the same malady and are therefore defective and ignoring the reality of what goes on and what has gone on during 2+ years. This isn't something that just happened over a short period of time. We're talking about years. And we're not just talking about the turnpike, we're talking about the DOT, we're talking about the transit.
Are you aware
None
of
of them
any
have
other
brought up this issue of this, what are we doing with this power of attorney?
Has this issue come up with any surety other than Liberty Mutual?
No, not to my knowledge. Liberty Mutual, though, issues 90, I mean, I can't give you the court the exact number as an officer, but the fact is Liberty Mutual is the game. They are the ones who issue this. That's why in a 2+ year period, they issued over 200 of these using the exact same forms.
The other bidders, did they have different sureties?
There were 5 bidders. 2 of the bidders, I believe, Senzari and Ferrara had different bid bonds, and D'Annunzio and one other and El Sol all had Liberty Mutual and all had the exact same situation here.
We've used a lot of different terms to describe the different bonds. Does the term surety bond have a synonym that we've used here today?
No, the fact is the surety bond can be, what is it a bond for? Typically, there's a bond put forward by the surety as to the bid proposal, which is typically 10% of the bid amount. Thereafter, there is a performance and a payment bond that's issued because you can't lien public property. There's a payment bond out part of it, and there's also the performance part of it, which is guarantees that the contractor is going to perform the work, and the surety is the guarantor. And the bond doesn't go to El Sol; it actually goes between the surety and New Jersey Turnpike.
So there's no standard that surety bond always means proposal bond or surety bond always means performance bond.
And to a degree, that's why when they're saying it involves to bond such and such, you're now trying to parse that out and say, okay, well then it only applied to the bid proposal bond, and not accepting the fact that in the industry it applies across the board. They don't look at it as being, oh, this is just a bid proposal bond. And that's why there's no law, there's no case ever that I'm aware of in the United States jurisprudence where a bonding company issued a bid proposal bond and then didn't enter into the performance and a payment bond.
We can ask Mr. Abate this on rebuttal, but I wanted you to respond to it as well. Are you familiar with forms that companies other than Liberty use in the power of attorney that seemingly get around this problem?
Yes. And there's no question that if you look at the other bond power of attorney, that in it specifically makes reference to the bid proposal bond and the consent of surety in its language.
And has Liberty changed its form since for the New Jersey Turnpike Authority since the specs were changed in this case?
My understanding is they haven't for NJDOT, New Jersey Transit, or any of those. My understanding is that they have with regard to the Turnpike, because the Turnpike now has changed its specification and requires something different than El Sol and Mutual believed was required. Which is like the other side argument here was a power of attorney ever really required for the consent of surety? And under the original specifications, it's plain it wasn't. And it was plain thereafter that it was changed.
You said that it's standard industry practice, I think, to support the statement that the surety bond number corresponding with the bond number on the consent of surety means it pertains to both the proposal bond and the performance bond. Is that right?
I'm saying that the Liberty Mutual looked at this as a three document package, 1, 2, and 3, and the power of attorney applied to both the bid proposal bond and the consent of surety.
And that's standard industry.
And that's standard industry, and that's what they've been doing all along, is putting that one power of attorney, and they looked at it as applying to both.
And where in the record can we go to support that statement that it is standard industry?
Well, one, I believe you have the letters, you have the amicus curiae brief, I think, which is a lot of really good information for this court to look at that was submitted by the SFAA. And the fact is, I don't think it's been questioned that the documents that were submitted in this instance were exactly the same as submitted 13 times prior and found no problem. And then this 14th time, over a year plus, is now, oh, we got a problem.
But it's not standard industry practice that the power of attorney references only a bond, because even in this case, as you said before, Sanzari's power of attorney referenced the consent of surety.
Yes, I'm when I say that standard, I refer to Liberty Mutual and the way that they've done it historically. I'm not trying to say that there is an SFAA standard across the industry as to what the power of attorney says.
Other questions, anyone? Anything you'd like to add, counsel?
No, other than thank you very much. I really appreciate this opportunity to speak to you all. And I appreciate the fact that I believe I was heard, and look forward to your decision.
Thank you. Mr. Abate, rebuttal?
Questions.
Thank you. Thank you to both counsel for the very helpful arguments and the obvious preparation that went into that. We're going to take a brief recess and come out for the next case.